Welcome back. In a judgment that is bound to raise eyebrows again, the Bombay High Court has ordered the unconditional release of the accused juvenile in the Pune Porsche road horror. In its judgment, the High Court upheld the objection filed by the teen's aunt that the continuation of the accused at an observation home was illegal. A bench comprising Justice Bharati Dangre and Justice Manjusha Deshpande observed that the court is bound by law as well as the aims and objectives of the Juvenile Justice Act and must treat him as any child in conflict with law separately from adult, despite the seriousness of the crime. The court further reiterated that since the child in conflict with law is under 18, his age needed to be considered. This is consistent with the High Court's observation a few days ago, in which it had observed that the accused too was also in trauma and needed to be given time. The court also went on to say that it is unfortunate that an accident such as this happened, but the outcry among people cannot be the basis of a subsequent judgment. The ruling came on a habeas corpus petition by the boy's aunt, who had sought his release from a government observation home. The teen will now be under the care of his aunt, as his parents and grandfather have been arrested for an attempt or an attempted cover-up.
Significant update which has come from the High Court is that the writ petition has been allowed. How do you see this?
Post the hearings of both the sides, even the prosecution aggressively opposed the particular writ petition. Both the sides were heard at length, but today the Honorable High Court has passed a judgment in favor of the legislation. And the CCL, the child in conflict in law, has to be released immediately. Yeah. The paternal aunt is the petitioner. So definitely the custody can be granted to her. Right. There are many other relatives at his residence. Right. So he's safely there in their custody. Right. So he can be released in their custody. Right.
A psychologist has also been appointed. Can you just...
So according to the scheme of the Juvenile Justice Act, a psychologist is already appointed in this matter, wherein the child in conflict in law has undergone almost 4 to 5 sessions, as I know, according to his instructions. And the sessions of the psychologist should continue, is the order of the Honorable High Court.
Right. My last question, will the minor be released today?
He has to be released today immediately, according to the orders.
मुझे पूरा विश्वास है अपनी न्याय व्यवस्था में, उनने भी कुछ सोच के मतलब ये फैसला किया होगा। और आगे बस मेरी एक रिक्वेस्ट है न्याय महोदय से कि एक माँ का दर्द समझे। मैंने अपने एक बेटी को खोया है, तो उस स्थिति में मतलब क्या वजह है, क्या है, उस हिसाब से मतलब उसको सज़ा दे। तो बोलना चाहिए कि इस केस में सही न्याय हो तो जनता भी अपनी न्याय व्यवस्था पे भरोसा कर सके। और मुझे पूरा विश्वास है कि मुझे ज़रूर न्याय मिलेगा, क्योंकि महाराष्ट्र सरकार ने भी हमें पूरा विश्वास दिलाया है कि न्याय होगा।
And I'm being joined at this point by PK Jain, who's a retired senior IPS officer, Nilesh Tribhuvan, who's a senior lawyer, and Aditya Pratap, who's an advocate. Thank you very much, all three of you, for joining us. But please allow me 2 minutes. My colleague Nilesh is currently with us. Nilesh, I have a couple of questions. We have guests waiting, but it's important to get the context. Nilesh, explain to us, one, the bail was granted. There was an absolute furore because among what was told to this juvenile who was involved in drunken driving, who was involved in speeding Porsche and the Porsche eventually killing 2 people, he was told to write essay, meet a psychologist, go and write an entire essay after being an understudy for the traffic rules. After the entire outcry and furore, the police went on to say that they are going to file sections under non-bailable charges. Now, my question is, was the bail cancelled at any point? Did the police move for the bail to be cancelled? Were the legal processes done at this point? Because the police said they want him to be tried as an adult. But the fact is he was granted bail by the Juvenile Justice Board. Was that challenged?
Well, absolutely. It is a big relief for the Agarwal family and for the juvenile who has been into observation center for more than a month now. However, an outcry is yet again seen after this judgment of Bombay High Court has been pronounced. And we also spoke to the family members of the deceased, and they also, expressed their unsatisfactory response in this particular manner. And while we are speaking, we can see the family members of the juvenile are again entering into this observation center. I would request my video journalist to show you the footages. These are live footages where the family members of the juvenile are yet again reaching to the observation center. At moment we were speaking to the advocates, and they mentioned to us that the juvenile won't be releasing today, but looking at this picture, it seems like again play is being made even after the judgment. While speaking of the decision that has been made, of the legal aspects, there has been basically two major observations made by the respectable Honorable High Court, which mentions that at first the bail which was granted by the juvenile board was extended by Pune Police without cancelling it, or without putting into any application before the bench that this bail should be rejected. It was only amended, and it was extended for further days, which as per Article 14 of the GGB should be considered as an illegal act. The second point which you asked for, that is, did the police try to put their say or extend this observation custody? Yes, Pune Police, as we spoke to the sources, did mention that we would like to extend our observation custody. However, the High Court denied to this extension. And a third point being that the Pune Police mentioned that since the family members of the juvenile are behind the bars, there is nobody to take care of this individual. However, the Bombay High Court mentioned that since the habeas corpus plea is presented by one of the parental aunt, and hence she would directly become one of the individuals who would monitor for further days.
Right, Nilesh. Right, Nilesh, thank you very much for joining us, and my colleague showing how the family members have gone inside, yet again inside the observational home. Mr. Nilesh Tribhuvan, you believe that what the court has done is right. Aditya Pratap, you believe that it could have been done in a better way. But my question is, beyond what could have been done better or what was right, what does the law really say? Aditya Pratap, the court has gone on to say that the Juvenile Justice Board's amended order was after an outcry. Isn't that a very sweeping statement? Are we then saying the JJB from day one of hearing this entire case to day two of eventually amending the order, and the whole furor or the action that was taken eventually was completely a sham? Is that how we are supposed to see? Common people, is that how we are supposed to see?
Well, before I begin, I would like to recall a statement I had made on this channel. People say law is an ass. I say in the 21st century, law has to be a vigilant eagle. You know, there is a saying that there is a legal principle that you cannot do a fraud upon the statute. You know, you cannot cite legalese and then get away with your wrongdoings. First and foremost, when we talk about the grant of bail in 17 hours, does it happen? You know, the Juvenile Justice Act, which came out in the aftermath of Nirbhaya, it was not meant to unveil a red carpet for children in conflict with law. The purpose of a remand home.
No, Aditya, but in that case, he was given a bailable offense by the cops. So it was not like there was a case where he was given a non-bailable case. Initially, the case was under bailable. He got the bail faster or slower. That's a different point.
Exactly.
The point is, what seems to be right now is the whims and fancies. Where's the law?
See, first and foremost, exactly when the court, with utmost respect for the Honorable Bombay High Court, if the court is of the opinion that his bail was cancelled and he was taken back into juvenile court based on the remand home, based on an outcry, well, I said very logically, why did the outcry happen? The outcry happened because the accused was a rich and a powerful person, because the system was being perverted from top to bottom. So in my utmost respectful dissent, I would like to submit that merely citing an outcry is not given by whims and fancies. In this country where we have seen the Sanjeev Nanda case, we have seen Salman Khan has so many hit and run cases of rich and powerful persons. The outcry, the judge the outcry has arisen from a reason, and the court should ignore the outcry. Honorable court should have looked at the entire chain of circumstances. 17 hours the bail is being given, not even a chance to, normally at least
Okay.
2-3 days lapse,
All
a
right.
chance is given to oppose the bail.
Okay. Nilesh Tribhuvan, let me come to you at this point. Now, I understand the heart of every juvenile justice board, the Juvenile Justice Act, the act under which children, accused teenagers as well, are tried, is to ensure that they are given the due course, that there is correctional measures that are taken place, and there is no undue advantage to them. But here, what we are seeing, how do you look at what the court has said? Because there are two aspects to this. One, what the police claimed. One, what the JJB, that's the Justice Board, claimed. And two, what the High Court has claimed. The three are completely different in very different dimensions. I mean, if you look at what the court has said, it's shocking. The court has said that JJB had no jurisdiction to keep the child, the teen accused in this particular case, for 25 days. So if that has happened, it's a complete travesty of justice. On the other hand, how was this child, a teenager accused, given bail in just a matter of few hours and out after he was drunken driving, speeding, landing up killing two people because of this accident, allegedly? This is all allegations, cases, charges that have been filed. And then you have him out on bail in no time because he's a teenager. I mean, either ways, this doesn't seem as if it's operating within the course of law.
Okay, now let me answer it one by one. So I firstly disagree with Mr. Aditya, my learned friend, on a 2-3 fronts. Number one, my learned friend is forgetting when the juvenile is involved in such kind of an offences, it's all solely depend on what sections our police have imposed. When he was produced before the Juvenile Justice Board, at that point of time, there was no section which was punishable lesser than, minimum punishment was lesser than 7 years. So that kind of a provision was not there. So there was no occasion for the court to even consider the aspect of treating him as a minor, as a major while granting the bail. So the court has solely followed what was there on the paper at that point of time. After that, when the court had passed an order, immediately, the public anger erupted on the newspaper, media, wherever. And thereafter, the police had filed an application for amendment of the bail application, rather than filing a cancellation of a bail application challenging the order before the superior court. Rather than doing so, they went before the same court, asked them to modify the order. That itself was illegal. There is no procedure in law which provides any modification of the same order. I mean, the same court cannot modify its own order. So the same, on the very basis, same ground, the petitioner's lawyer had approached the Bombay High Court, and the Bombay High Court had observed the exactly same thing. So you're saying what the
police did and eventually what the JJB acted on is illegal. That's what you're
Correct.
trying to explain.
Of course. The High Court also says the same thing. High Court also says the exact same thing, that the order itself is illegal. There is no authority. There was no power to keep him under the remand.
All right.
That's what the High Court is saying. And then, legally speaking, also.
Okay, PK Jain, let me come to you. Mr. PK Jain, Okay, sorry. Mr. PK Jain, you're a very senior police officer who's retired after holding several important posts. Has the police already botched up this case? Have they failed to do what they are meant to do? Sir, you have to unmute yourself. You're on mute. So you have to unmute yourself, sir. Unfortunately, we can't hear you. You're on mute.
Can you hear me now? Can you hear me now?
Yes, I can. Please go ahead.
I am already unmuted. Hello? Hello?
Go ahead, sir. Go ahead.
Yeah. Okay. See, Sneha, thanks a lot for inviting me to the show. Let me put the facts straight. My friends have not got the facts straight at all. The police had earlier applied Section 304A, which is Rash and Negligent Act driving. Subsequently, before the case went before the Juvenile Justice Board, the sections were amended. Section 304 was applied. It was the Juvenile Justice Board which had acted in an erroneous manner and granted bail or let the juvenile off the hook within 17 hours. So that was first part. Second part is, now what the High Court says, what I understand from the entire conversation is that what the High Court says is that the Juvenile Justice Board cannot revise its order without an application from the police to revise their order, which has not been done. So it is only technicalities that we are playing upon. The fact remains that high and mighty in this country are roaming scot-free without facing the law. He may be a juvenile. His application for him to be treated as a major, I don't know what stage is that at. So the fact remains that because he has got resources, his family has got resources, they have been able to put probably a good advocate on the case. He has obtained bail from the High Court. That's my personal opinion. He should have been tried like a major. He should have been incarcerated in a jail, now shifted to a jail for a longer period, which has not happened. See, in this country, unfortunately, different views are taken by different judges. There's a lower judge who passes an order which is turned over by the higher judiciary. Then that order is again turned over at the next higher level. So that always happens. So now in this case, since the High Court has taken a view, that view will hold till the time somebody goes in appeal or some other twist is given to this particular case.
Okay.
Otherwise, this order is final. He will be walking out of that remand home either today or maybe tomorrow morning. It all depends on the order when the copy is served on the concerned remand home. Sneha.
Right. I mean, to our viewers, we have three panelists with three different views. That's our job, to get you the different perspectives of this. But there are also facts in this case. My team has put these facts together. There was late reporting to the wireless control room after the crime, delay in taking blood samples of the accused, preferential treatment to the accused at police station, an entire nexus that was eventually unfolded where even doctors were involved in changing of blood samples that were collected from laboratories, switching blood samples of accused, efforts to frame family driver, allowed NCP MLA's visit to police station, lapses after lapses. And even as our panelists bring us different views, it is important to tell our viewers, we are not baying for blood. We are not here asking for the accused teenager to be ensured that XYZ should be done to him, the punishment, a certain kind of punishment should be given to him. What we are questioning is an absolute failure of the police and the legal machinery, and that is a point that is very important to be driving. From the day one of this case being reported, the manner in which it was reported, to what the police did, to what the police eventually did, to how the JJB's law was amended, to how it was finally furnished, to how the child, I'm saying a teenager, but actually he's an accused teenager. Remember, he was driving in an inebriated condition. Police has gone on record to say this. He was speeding in his Porsche, and while driving, he killed two people as part of the accident. And remember, this person eventually has stayed on in the correctional home, observation home, for say 25 to 28 days. And the court now says under whose jurisdiction? There's no jurisdiction to keep him in the observation homes for so long because he's out on bail. Strong questions on our legal and our judicial system that India does need an explanation for that matter. Thank you very much, Mr. P.K. Jain, Nilesh Tribhuvan, as well as Aditya Pratap for joining us.